How to incorporate a document by reference in the California Code of Regulations, and how to properly identify documents relied upon when adopting, amending, or repealing a regulation. Presented by the Office of Administrative Law. The Office of Administrative Law reviews proposed regulations from more than 200 executive branch state agencies in California to ensure compliance with the Administrative Procedure Act. Our office is also responsible for transmitting these regulations to the Secretary of State and for publishing these regulations in the California Code of Regulations. The California Code of Regulations can be viewed for free on our website at www.oal.ca.gov. How to incorporate a document by reference. Section 20 of Title I of the California Code of Regulations. Incorporation by reference means the method whereby a regulation printed in the California Code of Regulations makes provisions of another document part of that regulation by reference to the other document. A rulemaking agency may incorporate a variety of documents by reference, such as forms, guidelines, manuals, standards, or other documents the rulemaking agency wishes to become a part of the regulation. Incorporation by reference of all or part of a document into a regulation must satisfy the requirements in Section 20 of Title I of the California Code of Regulations. In order to properly incorporate a document by reference, the regulation text must state that the document or part of a document is being incorporated by reference, identify the document by title, and date of publication or issuance. Please note, the version of the document identified in the regulation text is the version that will become part of the regulation. Typically, prospective incorporation of future regulatory changes is not permitted unless a California statute or other applicable law allows for it. Prospective incorporation by reference is generally not permitted because it would allow for a regulation to change over time as the document incorporated by reference changes without subjecting the change to the substantive and procedural requirements of the Administrative Procedure Act, including public participation. When proposing to incorporate a document by reference, the informative digest of the Notice of Proposed Action must clearly identify the document by title and date. The rulemaking agency must also demonstrate in the final statement of reasons that it would be cumbersome, unduly expensive, or otherwise impractical to publish the document in the California Code of Regulations. The rulemaking agency must also demonstrate in the final statement of reasons that the document was made available upon request directly from the rulemaking agency, or was reasonably available to the affected public from a commonly known or specified source. Documents proposed for incorporation by reference are reviewed by our office pursuant to the substantive and procedural requirements of the Administrative Procedure Act. Assuming all substantive and procedural requirements are met, any documents incorporated by reference are attached to the Form 400 and regulation text for filing with the Secretary of State. When a regulation that incorporates a document by reference is approved by our office and filed with the Secretary of State, the document incorporated by reference is deemed to be a regulation. For more information about incorporation by reference, please see Section 20 of Title I of the California Code of Regulations. Documents incorporated by reference should not be confused with documents relied upon. Documents relied upon include all data and other factual information, technical, theoretical, and empirical studies or reports that the rulemaking agency is relying upon in the adoption, amendment, or repeal of a regulation. Documents relied upon are not identified in the regulation text, do not become part of the regulation, and are not filed with the Secretary of State. Rather, documents relied upon are included in the rulemaking record in accordance with Government Code Section 11347.3, Subdivision B7, to help justify the proposed changes to the regulatory text. Documents relied upon may also be included in the rulemaking record as support for a rulemaking agency's economic impact assessment or standardized regulatory impact assessment. If a rulemaking agency utilizes a document relied upon, Government Code Section 11346.2, Subdivision B3, requires that document must be identified in the initial statement of reasons. If the rulemaking agency adds a document relied upon to the rulemaking record after publication of the Notice of Proposed Action in the California Regulatory Notice Register, that document must be noticed to the public pursuant to Government Code Section 11347.1. Common examples of documents relied upon include professional studies, audit reports, expert testimony, and pre-notice workshopping materials. Please note, there is no need to include copies of existing laws as documents relied upon if the rulemaking agency is already subject to those laws. If you have specific questions about how to incorporate a document by reference in the California Code of Regulations or how to properly identify documents relied upon when adopting, amending, or repealing a regulation, please contact our reference attorney at staff@oal.ca.gov.